Hello friends, very warm welcome to my business laws channel. Today friends, I'm going to take a very controversial and important topic, which is, do daughters have the right to inherit property? Regarding this, I'll take up frequently asked questions with their answers. So let us begin with the first question. Who is an heir? Friends, heir include those persons who are legally entitled to inherit property from their ancestors. The second question is, who is a co-partner under Hindu law? As per the Hindu Succession Act, the co-partner is part of the actual Hindu undivided family. Therefore, it has a direct legal right to ancestral property by birth. Before the Amendment Act was passed in year 2005, only legal sons and sons of the immediate family were considered co-partners. So you all know, friends, after this Amendment Act 2005, now the daughters are also recognized as co-partners and have an equal claim on the property. And now coming to the next question, which is, what is ancestral property according to Indian law? According to Indian law, properties can be classified into two categories. The very first one is an ancestral property, and second is a self-acquired property. An ancestral property is in fact a self-acquired and undivided property of a person's grandfather. Okay, this property has been acquired, and it is undivided. It has been acquired by the person's grandfather, and it is undivided. Or in other words, we can say an ancestral property is a property acquired by your great grandfather. It has been passed on from generation to generation. Your grandfather and your father up to the present generation, that is you, without being divided or partitioned by the family. This is undivided. So coming to the next question, which is, what is the difference between ancestral property and inherited property? Friends, any property that is gifted or inherited through a will after the predecessor's death is called an inherited property. An ancestral property is in fact a self-acquired and undivided property of a person's grandfather. In other words, properties that pass on from the ancestors are called ancestral properties. So already I've defined this, just I have repeated. Coming to the next question, friends, very important question, very controversial. Do daughters have a right to inherit property? Or are daughters co-partners in father's ancestral property like sons? As you all know, the friends, sons used to be the only co-partners in their father's property earlier. But what is the current law now? That I'm going to answer here. In India, as we all know, daughters' rights to their father's property have always been controversial. That is why, I've told you, and you all know, it's a very controversial topic. It is a well-known fact that women have always been treated inferior to men. The day woman takes birth on the earth, and when she understands she is in her infancy stage, she is always told by her parents, mother, father, or the people who bring her up, that men can do this thing, you can't do this. Okay, so friends, she is always treated inferior to men, both in terms of inheritance rights and the capacity to hold property independently. And many restrictions were imposed on both inheritance and women's property rights in our country. With the social equation changing rapidly in recent years, a need for equal rights in father's property was felt on constant basis. There was repeated demand that some changes must be made. So as a result, in 2005, an amendment act was added to the Hindu Succession Law 1956. This was done to ensure that the daughter has an equal right to the father's property, whether she is married or she is unmarried, regardless of her marital status. Today, friends, the succession and inheritance laws in India have undergone several modifications and reforms via amendments and legislations. So consequently, daughters now have an equal share in the property like sons. Both have their equal rights. To be more specific, friends, gender is now hardly any factor to be taken into consideration because of the daughter's right on both coparcenry and self-acquired property. So moving ahead, friends, now at present, a daughter can acquire, hold, and dispose of property at par with any other man. Today, there are practically no restraints on a woman's capacity to acquire, hold, and dispose of her property. She can acquire the property, she can hold the property, and if she wants to dispose of the property, she can also dispose of the property as the men can. Then daughters have an equal share in their father's self-acquired property as well as ancestral property. In both the properties, whether it is self-acquired property or it is ancestral property, daughters have the equal right at par with men. And now, friends, moving ahead, next question I would like to take up, which is, what was the Supreme Court decision in Vinita Sharma case? On 11th August 2020, the Supreme Court of India passed a landmark judgment in Vinita Sharma versus Rakesh Sharma case, stating that the Hindu Succession Amendment Act 2005 will have a retrospective effect. The 2005 amendment amended Section 6 of the Act in order to align with the constitutional belief of gender equality. Both the genders are equal now, whether men or women. There is no gender inequality now. Now, next question is, friends, can the daughter claim the father's property when the father is alive? No. The daughter or the son, whether he is the daughter, she is the daughter, or the son is the son, can only claim the father's property in the event of his death. Can a married daughter claim the father's property? Yes, the right of a legal daughter to her father's property does not depend on her marital status. Friends, as already pointed out, whether she is married or she is unmarried, in both the cases, she has the equal right. Marital status will not affect her right to share the property of her father. Next question is, friends, can a daughter claim the ancestral property of her mother? The answer is yes. Yes, the daughter has an equal right to inherit the traditional property of her mother. But friends, that too after the death of her mother. They cannot claim the property during the lifetime of mother. So this right is available to the daughter, but only the death of her mother. Can a daughter ask for the partition of her ancestral property? Friends, daughters, irrespective of their marital status, can ask for the partition and equal share of the ancestral property of their parents. This is null and void in cases where a will has been made stating the deceased person has distributed the property in favor of his son and not the daughter. If the will has been left and the property has been, favored, has been given in favor of son only, then only, daughter will not have the right to ask for funds. Moving ahead, friends, now this is the second last question. What are the rights of daughter in father's property if he dies without will? He has not written the will. But then, what will be the rights of daughter in father's property? On the death of a person, his or her property is distributed amongst the persons as specified in the will. However, in case a person who dies without leaving a will, that is, he dies intestate. Intestate means that the person has died without writing the will. In such cases, the property would be distributed according to the law based on his or her religion. So then your distribution of the property will differ from religion to religion. The succession of Hindu, Jain, Buddhist, and Sikh is governed by the Hindu Succession Act. Muslim succession is governed by the Muslim law, and Christians are governed by the Indian Succession Act. And now the last question is, friends, how many generations can hold ancestral property? So what was the law for this? The earlier law. You all know, friends, in case of classified ancestral property that has remained undivided, 4 generations of the male lineage have their claim, used to have their claim. This means on Ram's ancestral property, his son Shivraj, Shivraj's son Meghraj, and Meghraj's son Yuvraj have inheritance rights. In other words, the father, the grandfather, and the great-grandfather and the great-great-grandfather have had earlier inheritance rights over an undivided ancestral property. But friends, now, what is the law now? After the amendment in the succession law through the Indian Succession Amendment Act 2005, the women have been accepted as co-partners. You all know, earlier also in this video, I had made a mention of this. Now both sons and daughters are co-partners in the family and share their equal rights and liabilities over the property. A daughter remains a co-partner in the property even after her marriage. So marital status will not have any impact on the daughter's right to share property. Friends, it is all about this video today. So friends, I hope you will like the content. Do subscribe to my channel if you have not subscribed yet. If you have subscribed already, then I'm very thankful to such viewers for watching my videos. Do press on the bell icon for getting notification of the future videos. Friends, stay happy always and God bless you all. We will meet soon. Goodbye.